During the day today, the Aam Aadmi Party also decided to fight it out from the streets all the way to the court, protesting against the arrest of the Chief Minister. Security was also stepped up around the city with heavy personnel deployment and multi-layer barricading on roads leading to the BJP headquarters. In fact, Aam Aadmi Party ministers Atishi, Saurabh Bharadwaj along with party workers were also detained amid these demonstrations, and Section 144 was imposed at ITO and around the Aam Aadmi Party office. Meanwhile, the Delhi court has reserved its order on ED's plea seeking Kejriwal's remand. The order will be passed shortly. Interestingly, Kejriwal's arrest is a first for independent India when a serving chief minister has been arrested. It marks a defining moment for opposition parties from the India alliance and those outside like the Trinamool Congress to unite once again against the government at the centre. They are calling it death of democracy, accusing the centre of a heavy-handed crackdown on the activities of the opposition in the run-up to the election. In fact, the Congress party too has accused the Bharatiya Janata Party of controlling the income tax department because all its bank accounts had been frozen in connection with the ongoing tax dispute.
राष्ट्रीय पार्टी है, राष्ट्रीय अध्यक्ष
पूरी तानाशाही है। सिर्फ और सिर्फ लोकसभा चुनाव जीतने के लिए ये तानाशाही की जा रही है।
इनको भी जेल में जाना पड़ा। सुप्रीम कोर्ट से लेके अन्य कोर्ट ने उनको राहत नहीं दी। क्या अरविंद केजरीवाल कानून से ऊपर है?
ये कौन सी जादुई पुड़िया खाई है सत्तारूढ़ पार्टी ने कि हर अच्छाई वहाँ है, हर बुराई यहाँ है।
उन्हें किसी चीज के लिए गुनहगार पाया नहीं गया है। जेल में बंद रखना ये भी उनके साथ एक सोची समझी साजिश है।
All right, and we're getting in an exclusive news break as far as Kejriwal's custody that's being sought by the Enforcement Directorate is concerned. CNN News18 has in fact accessed the remand application of the Enforcement Directorate against Arvind Kejriwal. It says that the Delhi CM conspired with other persons and was involved in the formation of the liquor policy for facilitating taking of kickbacks and has played a role in the generation, use and concealment of the proceeds of crime, and that is what makes it extremely crucial, because remember, it was in 2013 that amendment was brought in, not during the NDA but during the UPA government, which spoke about the proceeds of crime and the prima facie evidence of who receives that proceeds of crime makes it extremely significant. In fact, let's quickly go across to Ananya. Ananya, could you share the details of the remand application with us?
Well, definitely. There are various, points that come out of this remand application. The most important being that the Aam Aadmi Party was a big beneficiary, and in fact, I quoted from the remand note that the Aam Aadmi Party is a major beneficiary of the proceeds of crime generated in the Delhi liquor policy. In fact, the part of the proceeds of crime was to the tune of 45 crore. That has been utilized in the Goa elections. Not only that, but it is also stated that Arvind Kejriwal has been interestingly involved in the entire conspiracy of the Delhi liquor scam, wherein the policy was drafted and implemented in a manner where certain persons can actually be favored and benefited in a quid pro quo or their recovery due to the actions of Sri Arvind Kejriwal involving in the policy formulation, hatching conspiracy of kickbacks with the South Group members, and eventually using a part of that proceeds of crime generated out of the scheduled offence in the election campaign for Goa. It's an assembly election. It is clear that all these activities were not only done with his knowledge, but also with his active collusion. So basically, Kejriwal, one of the major kingpins, big charge coming in. Not only that, but it's also very, very clear, and it's from the submissions and from the remand note that this policy change was only and only to fund the Goa elections and nothing else. Apart from that, big details, the money trail also comes out wherein statements of, in fact, the Aam Aadmi Party's treasurer are also involved, wherein they go on to, ND Gupta goes on to say that nothing in the party requires, approval. If Arvind Kejriwal wants to do it, he can, being the CM of the party, very well do anything without any kind of approval from any committee of this particular political party, even with the constitution of that particular party.
All right, many thanks to you, Ananya, for bringing in that big news break for us. And with that, let's now shift focus over to what have been the charges. In fact, as far as the Enforcement Directorate is concerned, let's try and decode the storm of charges in the court. The Enforcement Directorate has alleged that the Delhi Chief Minister is the kingpin, even sought kickbacks from liquor barons. What was the rebuttal by Kejriwal's legal team, where they said that the first time in India's history a sitting Chief Minister has been arrested and that it cannot be done without keeping the timing in mind. The ED has also gone on to say that Delhi's Chief Minister directly was involved in formation of the excise policy, to which Kejriwal's legal team has said that ED has not established the necessity for arrest. Remember, Abhishek Manu Singhvi has in fact clearly dichotomized that there's a difference between the necessity and the ability to arrest. The ED has also gone on to say that Vijay Nair acted as the middleman between Kejriwal and the South group, and that is the big evidence also that they have. Kejriwal's legal team has in fact come up by saying that majority of accused have not mentioned the dealings with Kejriwal. The ED has also gone on to quote YSRCP MP Magunta Reddy, saying that the Chief Minister wanted 100 crore for polls. Well, they are of course referring to the polls in Goa. Kejriwal's legal team has said that the weight of these statements can only be considered during trial and not when custody is being sought. The ED also goes on to say that Vijay Nair received 100 crore worth of kickbacks, this on behalf of Delhi's Chief Minister. Kejriwal's legal team has come up with the rebuttal, saying that tracing the money trail is absolutely no ground for arrest. The ED has in fact accused them that their Hawala trail of 45 crore has been traced for Goa election funding. Kejriwal's legal team has come up by saying that no need for arrest over contours of alleged crime. The ED has also quoted MP MS Reddy, saying that he was asked to arrange 10 crore payment to K. Kavita, the BRS leader. Kejriwal's legal team, to which has said that there is no direct evidence against Delhi Chief Minister with regards to this. The Enforcement Directorate has also said that apart from personal role, Kejriwal's role via Aam Aadmi Party is important. Kejriwal's legal team has said that ED has misled the court over reasons for summons and that this arrest is illegal. The ED also says that during the search, Delhi's Chief Minister was not being cooperative. Now remember, this is that legal argument on which the entire arrest has also been hinging on, to which Kejriwal's legal team has come back saying that the larger issues of democracy involved in this case and that this is a crackdown on the opposition parties. And that brings us to the big burning question that we are posing to our panelists today with regards to the showdown surrounding Arvind Kejriwal's arrest. Is it an anti-corruption crackdown or pre-election conspiracy? And with that, let me introduce my guests today. I'm joined in by Pratyush Kant, who's the national spokesperson of the BJP, Satyendra Singh, who's the former deputy director of the ED, Piyush Joshi, who's a political analyst, and Anmol Panwar, who's a spokesperson for the Aam Aadmi Party. Many thanks to you, gentlemen, for joining in. In fact, I'd like to take my first question from you, Mr. Singh. There's a lot of allegation about how central agencies, primarily in this case the Enforcement Directorate, has been unleashed on the Aam Aadmi Party and the other opposition parties as well, and that it's been given more muscle and teeth during the NDA regime. But I want to know from you, is this just a development during the NDA regime? And how do you assess it? Is it not the government's way of cracking down on money laundering and black money?
आकांक्षा जी, देखिए ये गवर्नमेंट जो है, यदि यूपीए से आप कंपेयर करते हैं तो मनी लॉन्ड्रिंग जो है एक्ट जो है वो बड़ा इनिशियल स्टेज पे था इम्प्लीमेंटेशन के। उसके बाद चेंज हुआ, ऑफिस भी बड़ा हुआ, केसेस बढ़े। और देखिए पीएमएल एक इंटरनेशनल लॉ है, एक इंटरनेशनल ऑब्लिगेशन है हमारे देश के ऊपर कि ऐसे करप्शन या जो है इन चीजों के खिलाफ बड़ी तेजी से कार्रवाई की जाए। अब ये सवाल है कि अपोजिशन पे ही ज्यादा क्यों हो रही है? तो देखिए जो केसेस सामने होंगे उन्हीं के खिलाफ कार्रवाई होगी और ऐसा नहीं है, देखिए कुछ केसेज है बंगाल के हैं, कुछ और केस हैं, वो तो हाई कोर्ट्स ने ईडी को दिए हैं कि आप इन्वेस्टिगेट कीजिए, सुमोटो नहीं कर रही है ईडी। और जहां तक इस पर्टिकुलर केस की बात है
इसीलिए
तो
सत्येंद्र
देखिए
सिंह आपसे मैं ये भी पूछना चाहूंगी, 2013 में एक अमेंडमेंट किया गया था, वो तो यूपीए रेजिम के दौरान ही किया गया था, जहां पे प्रोसीड्स ऑफ क्राइम की बात की गई है कि द पर्सन विद द पोजेशन ऑफ दैट प्रोसीड्स ऑफ क्राइम इज गोइंग टू बी प्राइमा फेसी also going to be held up, and then that's one particular point that I want you to also shed light on, how this amendment did not happen during the NDA regime.
नो, ये तो यूपीए के टाइम में हो चुका था अमेंडमेंट, एनडीए के टाइम में नहीं हुआ है जी। कुछ जो ऑफेंस ऑफ मनी लॉन्ड्रिंग की डेफिनेशन है सेक्शन 3 में, उसमें कुछ वर्ड्स इंसर्ट किए गए, कोई मेजर चेंज नहीं किया गया। और जितने भी अमेंडमेंट्स हुए हैं, देखिए सुप्रीम कोर्ट ने उन सबको अपील्ड किया है। कुछ चीजों को उन्होंने अपील्ड नहीं भी किया, जैसे प्रॉपर्टी के पोजीशन का इश्यू था, सुप्रीम कोर्ट ने कहा नहीं, आप इमीडिएट पोजीशन लेने की कोई जरूरत नहीं है। तो ऐसा नहीं कि पूरे के पूरे एक्ट को ही उन्होंने या सारी पावर्स को अपील्ड किया, कुछ जगह डाइल्यूट भी हुई थी सुप्रीम कोर्ट के जजमेंट के पास। अब ज्यादा इश्यू कहाँ आता है कि सिर्फ बेल को लेके आता है कि बेल नहीं हो रही लोग, और वो भी सिर्फ पॉलिटिकल केसेस पे ध्यान है। आप देखिए पॉलिटिकल केसेस हैं कितने, 2% ऑफ द टोटल केसेस। बड़े बड़े कॉर्पोरेट बंद हैं, बड़े बड़े लोग बंद हैं, उनकी भी बेल नहीं होती, उनके बारे में कोई बात नहीं करता, क्योंकि शायद कि किसी का इंटरेस्ट नहीं है उसमें। सिर्फ पॉलिटिशियंस का जब सवाल आता है तो ये बड़ी बड़ी बातें की जाती है, एजेंसी पे आरोप लगाए जाते हैं कि एजेंसी जो है।
All right, and that is the point that I will be taking forward with my guests today. Pratyush Kant, if I could bring you in on this aspect, when we talk about the major allegation coming in from the opposition when they are accusing your party of resorting to a pre-election conspiracy because it is the timing that is now being questioned. Let me refer to this urgent memorandum that has been submitted to the Election Commission of India by the opposition parties that got together, not just from the India Alliance but also outside parties like the Trinamool Congress. In fact, they've gone on to quote 10 cases where the ED and the income tax have in fact been unleashed on the opposition party, and this in fact these 10 cases span all the way from 5th of January till 21st of March itself, just 10 cases. They have also listed how central agencies, particularly the ED, have been going behind leaders from the NCP, the Trinamool Congress, the Congress Party, the Aam Aadmi Party, all of them over here. How do you react to this urgent memorandum? They've also accused your party of misusing the timing.
Well, if you make money in this country by illegal means, you are trying to steal the money of the taxpayer through commissions, you have to pay a price for that. All of us have seen the hordes of cash which we got from TMC guys in Kolkata or in Jharkhand. And in this particular case, in Arvind Kejriwal's case, where is the question of timing? It's an ongoing process. If an FIR is for, the day you file an FIR, you have to bring the case to its conclusive end. How do you bring the case to its conclusive end?
But Pratyush Kant, the allegation is also that that you are paying for the opposition parties only.
See, you have to understand something. That's what I'm trying to explain to you here. Just have patience. There is a case which is registered many months ago. You investigate. You take time to reach to the end. And please tell me, 9 summons you don't go. Do you think BJP was timing it? Why didn't you go on the first summon, the first day? Please, I respect your channel, I respect you, but please.
No, in fact, I will bring Anmol Panwar on that.
9 summons you are not going.
Fair enough. That is also the question that legal experts have been posing to the Aam Aadmi Party.
You know you were corrupt.
Point taken, Anmol Panwar. How do you react to the allegation that Mr. Kejriwal, right from the beginning, was only dodging the summons? Why wait for the 9 summons?
See, Akansha, this illegal and unconstitutional arrest of the most popular and sitting Chief Minister of Delhi indicates that India is under an undeclared emergency. The summons which were issued to the Honorable Delhi CM were illegal and politically motivated. We have challenged those summons before the Delhi High Court day before yesterday. The ED vehemently opposed the summons and the maintainability of the petition, but the Honorable Delhi High Court rejected all their contentions and issued notice and asked them to reply within 2 weeks. The matter is sub judice, and it is for the court to decide after hearing both the parties whether those summons were legal or illegal, whether Mr. Kejriwal was supposed to appear before the ED on the basis of the so-called summons.
Satyen Singh, if I'd want to in fact bring in over here, as far as PMLA is concerned, you're looking at very serious charges coming under the PMLA. And when you want to focus on PMLA and those particular summons that have been sent by the Enforcement Directorate, any ruling authority or any position of power in the government or outside the government, can it dodge those summons?
No. No one can. देखिए, लॉ एक है. अब आपको रेस्पेक्ट करनी चाहिए थी इन्वेस्टिगेशन. आप रेगुलर जो है मीडिया में कहते रहे कि सम्मन्स इलीगल है, लेकिन हाई कोर्ट में जो बेसिक प्ली इन लोगों ने ली है वो ये लिए कि हमें प्रोटेक्शन दिया जाए अगेंस्ट द कोर्सिव एक्शन. सम्मन की जो लीगलिटी है, सुप्रीम कोर्ट के भी कई जजमेंट है जिसमें सुप्रीम कोर्ट ने कहा यदि आपको सेक्शन 50 में सभी सम्मन दिया जाता है तो उसको आप चैलेंज नहीं कर सकते. आपको जाना है, आपको ये नहीं बताया जाएगा कि आपको एज एक्यूज बुलाया जा रहा है, विटनेस बुलाया जा रहा है. इस पे बहुत सारे जजमेंट है, लीगल पोजीशन बहुत क्लियर है इसके ऊपर.
Sure. Anmol wants to come in on that. Right. Go.
The judgment of the Honorable Supreme Court Pankaj Bansal versus Union of India says that under Section 50, read with Section 19 of the PMLA Act, if a person is called as a witness, then mere non-cooperation cannot be a ground for arrest. The Counsel for the Enforcement Directorate admitted yesterday that neither Arvind Kejriwal is an accused, nor Aam Aadmi Party has been made an accused. Then it is for the BJP to answer. It is for the Enforcement Directorate, which is working at the behest of Bharatiya Janata Party.
Who is Vijay Nair? No. That is why the custody battle is being fought over right now. Sure, sir. Let Pratyush in fact.
Now when you are talking legality, let me tell you, there is a laid down law of the Supreme Court in Tamil Nadu case when they were trying to protect bureaucrats. Supreme Court has categorically said that if summons are issued, you have to go. The biggest question here is that why was Arvind Kejriwal running away from these summons? He was absolutely sure with every arrest that was taking place in this case, he knew that his days are numbered. That is why he was trying to buy time. Who can run away? You get a traffic challan and you run and you go to the court and you pay the fine. You get an MCD challan, you run to the municipal body and pay challan. And here you're getting a summons from ED and you're running away from it. Why? Because you always knew that you are the kingpin of the whole game. The law is going to catch up to you. And you are trying to quote judgments. Which judge?
Right.
Let us go to Delhi High Court 2 days ago. What happened? What happened in Delhi High Court? The Lordship refused to listen to the case. Why? None of them had ever pleaded in the court that these summons are illegal. They were asking for protection. Under which section of law you are asking for protection? You make money. Then every bureaucrat,
those are some valid points. We've also read, we've all gone through those charges by the ED over there. There is an MS Reddy, there is a Vijay Nair, and now a K. Kavita also that the ED wants her to be confronted with an Arvind Kejriwal. Why not let the custody happen? If Arvind Kejriwal is innocent, let him face K. Kavita. And the fact of the matter remains that there is a Satyen Jain, there is a Manish Sisodia behind bars. They've not got bail because there is incriminating evidence.
Akansha, it'll be very hard for Pratyush ji to answer to the viewers that why one of the so-called prime accused, they used to say Aurobindo Pharma, whose director is P. Sharad Reddy. He was alleged as the kingpin of this liquor scam. He purchased Electoral bond on 10th of November 2000.
All right.
After 5 days, he donated those 5 crores to Bharatiya Janata Party, and thereafter, in 3 months, he was enlarged on bail. And the ground on which he was given bail, which ED didn't even oppose, was that he has a back pain. Same goes with Maguntha.
Pratyush, would you like to come back to that? Because, you know, we've been seeing a lot of whataboutery
Yes,
happening
absolutely.
over here. But I'll give you 30 seconds to come up with a rebuttal before I quickly go to Piyush.
In fact, may I?
No, let him finish. Let him finish.
The law.
Let Pratyush
No,
speak.
let me answer. Let us be sure about the fact that if Arvind Kejriwal has tried to demolish all the digital proof which is now being given to the court, let me take you back in a second. What happened when it went to the Supreme Court? When listen, I didn't interrupt you. Don't interrupt me. When it went to Supreme Court, the second senior most judge of the country, when he saw those documents which I and you have not seen, he said, I see a clear mark trade of 338 crores. Then from then on till his arrest, it had to happen, because every time a judge saw those documents which I and you have not seen, they could clearly see the evidence. That is why Arvind Kejriwal is in jail today. That is why Arvind Kejriwal got no relief from the High Court or from the Supreme Court. That is why he withdrew his case from the Supreme Court, because those documents are something which only the lordships are seeing there. No, neither I am seeing it nor you are seeing it.
You've made your point. Piyush, if I may come to you, we all know that Delhi is going to be heading into elections. As far as the 6th phase is concerned, we all know it's happening on May 25th. How will the developments that are currently unfolding for the Aam Aadmi Party be impacting their performance on 25th of May? A. B. There's also the allegation coming in from critics of Narendra Modi that it is the Bharatiya Janata Party's own threat perception regarding the welfare schemes of the Aam Aadmi Party, which has led to all that's happening today.
It is not only about Aam Aadmi Party. It is about the Jharkhand Mukti Morcha.
But today we are talking about Arvind Kejriwal, so let's stick to that.
I know. Yeah. So I am sticking to that. I'm just trying to cover the bigger picture here, because that is where the actions are justified as far as the BJP is concerned, because they have maxed out in 2019 in each and every state. They have performed remarkably when it comes to the 2019 Lok Sabha election. So where are they going to get those extra seats from, as the Honorable Prime Minister has been claiming? And that is why the states where the incumbent chief ministers are very, very popular, like the Jharkhand Mukti Morcha, Hemant Soren, like Arvind Kejriwal ji, who is going to affect 20-25 seats in total. So just put them behind bars. And in case of Aam Aadmi Party, you not only put the top leadership behind bars, you put the number 2, number 3, and number 4 as well behind bars. So if we look at it from that perspective, Sanjay Singh ji was not in Delhi government. Sanjay Singh ji was a Rajya Sabha MP. His PAs and his OSDs have been allegedly involved in the so-called liquor get scam. So through that, they have put Sanjay Singh ji again behind bars. So by demolishing, I am under no illusion. Just give me 10 more seconds and then I'll stop. I am under no illusion that it is going to be difficult for Aam Aadmi Party to contest. But I think there is going to be a sympathy wave as far as Delhi is concerned, because he is a popular chief minister. There is no doubt, and people will see this movement as this move of the BJP government as unjust.
Pratyush, would you like to come back to that? Because you're already seeing how the Aam Aadmi Party is at the moment trying to milk this. Will they be able to do this, and will this prove to be a turning point for the opposition's own unity? Because we've already seen how it's crumbling day by day.
I am appalled by what kind of debate and the points they are putting forward here. Now imagine you are talking about as if Bharatiya Janata Party controls judiciary. It's exactly what Rahul Gandhi and Sonia Gandhi were talking the other day, that you have to trust the constitutional bodies of the country. Judiciary, Election Commission, CAG, these are all independent bodies, they work on their own. We should stop challenging them. You are talking as if BJP throws somebody in jail and the guy never comes out of the bail. You will only come out of the bail if you are innocent. Otherwise, you will be put behind bars forever till the courts believe that you have completed your time of being behind the bars, whatever the time they allot to you. You have to understand, Indian judiciary, Indian democracy doesn't function like this. It doesn't function on somebody's whims and fancies. The courts are independent body, and it's high time such senior people sitting on your channel, they talk about court as if BJP controls the judiciary of the country. It doesn't happen like this, man.
Fair enough. That's a very fair point. That's a very fair point. Piyush Joshi answered that. When you, in fact, are including this, you're also including the legal bodies of the country, including the apex court as well. Are you saying that? Are you questioning the integrity of the judiciary?
Certainly not. Nobody is questioning the integrity of judiciary, but the judiciary has to function in accordance with the law of the land.
Which they are?
And no, precisely, so when we talk about the PML Act and its 2023 amendment, that is what I am interested in. That when you talk about the 2023 amendment, the judiciary has to work according to the jurisprudence. And the 2023 amendment does exactly that. It reverses the principle of jurisprudence. What does it do? Guilty until proven innocent. And my dear friend Pratyush is saying that you will go.
No. Piyush, I beg to differ over there. Are you forgetting that there was a Gazette notification in 2023 itself from the Finance Ministry, which also talks about politically exposed persons? And for that, I am actually going to ask Satyendra Singh to educate you. Satyendra ji, please go ahead and talk about that Gazette notification that had come, which categorically defines how the PEPs will come under the ambit of the ED.
No, that is what I am talking about. That is what I mean to say. That is the point.
Since you are referring to the amendment of 2023 as well.
Yeah, so that is precisely the point I am talking about. Okay, so that is where everything fits into the picture, because you change the principles of jurisprudence, you make laws which suit you, and then you use them in a manner that suits you. That is where the problem is. So judiciary, I don't blame the judiciary. Judiciary will adjudicate according to the law.
This is really getting very vague. Satyendra Singh, I'd like to leave you with the closing thoughts over there, because put this into perspective for us. The kind of Gazette notification, the kind of amendments we've seen happen in the year 2023 itself, which also go on to bestow more power upon the ED, and which is, I think, also a justification of why the Election Commission also right now is in a very ambiguous region when it comes to its own legal powers.
नहीं, देखिए, ये जो नए अमेंडमेंट्स थे, इनमें कुछ भी नहीं, कुछ क्लैरिफिकेशन से ऐड किए गए। ईडी को कोई नई पावर नहीं मिली, जहां तक जुरिस्प्रूडेंस की बात है।
वही क्लैरिफिकेशंस की बात हो रही है कि जब आप पीईबीज की बात कर रहे हैं, तो साफ उसमें आपके पॉलिटिकली पावरफुल लोग जो गवर्नमेंट में हैं, चाहे वो चीफ मिनिस्टर हो या कोई भी सिटिंग मिनिस्टर हो, वो भी इंक्लूड होते हैं कि नहीं?
जी हाँ, देखिए, लॉ सबके लिए। पीएमएलए में आप बहुत क्लियर है कि अरेस्ट या समनिंग या कुछ भी है, तो उसमें कहीं भी ये डिफाइन नहीं किया गया है कि ये पॉलिटिकली एक्सपोर्ट पर्सन है, पावरफुल है, इनके लिए अलग सेट ऑफ रूल्स हो। ऐसा सबके लिए सेट ऑफ रूल्स है, लेकिन फिर भी आप देखिए, इन प्रैक्टिकल अब जब हम देखते हैं एजेंसीज की वर्किंग, जितना समय केजरीवाल जी को दिया गया या कुछ और लोग हैं जिनको दिया गया, बार बार सम्मन दिए गए, जब भी इन्होंने एडजॉर्नमेंट मांगा, इनकी बात मानी गई, कभी किसी भी इश्यू पे। दूसरे, यदि आप सही कहें तो इनको एक तरह से वीआईपी ट्रीटमेंट मिला है। दूसरा, कोई साधारण नागरिक होता है, उसको इतना ट्रीटमेंट नहीं मिलता है, इतना टाइम नहीं दिया जाता है, ये एक सच्चाई है।
Satyendra Singh, I'd like to end with your thoughts. Is this a sorry state of affairs or stringent action against money laundering? That's I'd like to give you 15 seconds to end with that. क्या ये sorry state of affairs है या stringent action against money laundering?
It's stringent action against the offenders of money laundering. Actually, it's an international law. देखिए, शेड्यूल ऑफेंस की जो इंक्वायरी है वो सीबीआई या दूसरी एजेंसी करती है, ईडी कर रही है मनी लॉन्ड्रिंग के लिए, एंड ये एक इंटरनेशनल ऑब्लिगेशन है हमारे देश का दूसरे देशों के साथ मिलके। तो इसमें एकदम स्ट्रिंजेंट एक्शन हो रहा है, कोई गलत नहीं हो रहा है।
All right, I'm running short of time. Many thanks to you, gentlemen. Mr. Satyendra Singh, thank you for concluding with those thoughts. And in fact, the days ahead are going to be a defining moment for the political climate in India as far as the NDA versus the opposition, including the India Alliance, is concerned. And with that, it's time for a quick break. Thank you so much for watching The Hard Facts.
So the optimism is definitely not there in the Aam Aadmi Party cadre, because they have seen in the similar case what had happened with leaders like Manish Sisodia, Satyendra Jain, and also with Sanjay Singh. So as of now, all the eyes are on the courtroom, and in fact the cadre is also waiting for what is going to happen inside the courtroom, and then the further course of action will be decided by the Aam Aadmi Party.
Right, and I'm also joined by my colleague Anvit Srivastav. Anvit, I remember those scenes years back whenever Arvind Kejriwal would launch a protest against the corruption charges of the UPA regime. And in that time, the entire city, the national capital, used to be paralyzed given the mobilization of the Aam Aadmi Party workers. Now, yesterday, after Arvind Kejriwal's arrest, we saw a very strict security bandobast being done by the Delhi police outside Kejriwal's residence and even outside the ED office. Has that net now expanded to the entire capital, as not just the Aam Aadmi Party but the entire India alliance is up in arms?
Yeah, see, quite ironical, Anshuman, when this entire movement had erupted from anti-corruption movement, and Arvind Kejriwal rose from it, and eventually became the CM of the capital, and now he has been produced in this special court in charges of corruption and money laundering. So that certainly is ironical, and coming to the latest development, the hearing we are given to understand has begun in this case. Abhishek Manu Singhvi, who will be presenting him, has also reached the court, and he'll be physically be present inside the court, and we are being told that he has reached. You see this entire stretch, how heavily barricaded it is, and this is one of the gates from where the entry of vehicles are allowed, but this is not the gate from where the Kejriwal has been brought inside. He has been brought from the back gate, and he had been brought inside the court under heavy cordon, and this entire stretch, as you can see, has been barricaded. This at the barricade that we are standing at is at least the 4th or 5th level of barricading, because this entire stretch has been blocked. Just a short while ago, this entire stretch was vehicular movement was allowed. This was open, but just a short while ago, senior officers came here and they ordered their subordinates to shut this road completely. And now you see the kind of barricading that has been done, because no vehicle will be allowed here until this hearing goes on. And also because just a short distance from here there is Aam Aadmi Party's office, where heavy protests have been going on since early morning. All the Karyakartas, they took to roads yesterday also after the CM's arrest, and it was in this anticipation that Delhi police had made such elaborate attempts. Also, if we talk about what the case is right now, and what is the biggest fear of Aam Aadmi Party when their convener stands arrested, is the whether or not he'll get a bail like Manish Sisodia or Sanjay Singh, or he will stay inside jail for
Kavita, she has been arrested and whisked away by the Enforcement Directorate. She's also obviously extremely upset right now, given the fact that others in the Liquorgate scam have not really had their way in the court of law.
Mr. Sen, the election commissioners were always selected by the Prime Minister earlier as well. In fact, now there is a 3-member committee. It wasn't so always.
Why should we believe that just like Bengal was a breakout for the BJP in 2019, that the South will not be one for the BJP this time? Mr. Vivek Srivastava, you are not, as per your political ideology, allowed to define any religious faith, so don't attach any meaning to it without understanding what Hindutva actually is, sir.
Because PMLA, when we talk about Prevention of Money Laundering Act, the section 45 that deals with bail provisions, it clearly says that only if the court believes that the person is not guilty, or if they can vouch for that the person when he is out on bail will not commit another crime, only then bail can be granted. Also, the counsels who are representing the person on whose allegations have been levelled, if they manage to prove that the allegations are baseless, only in those conditions the bail can be granted. And this is one reason when even be it Manish Sisodia or Sanjay Singh, whoever have appeared in the court for asking for bail, the court have not been able to grant any bail. Even yesterday when Manish Sisodia, Arvind Kejriwal, he had asked for some relief from High Court. High Court also failed to give any relief, and they said that at this point of time they can't give any such directions. So these things will be kept in mind. Also ED would want his remand because they want custodial interrogation. They want to confront Arvind Kejriwal, who is the top person in this pyramid that they call the liquor policy scam, and they would want to confront him with each and every person who has been arrested, who are key people, who are key conspirators, as the ED calls them. Recently, after K. Kavita's arrest, ED had also called Arvind Kejriwal as one of the conspirators in the case, and therefore they would want to confront them so that the money trail that is being investigated in this entire case, the 100 crore kickback that was allegedly received and the money that was used in Punjab and Goa elections, that can be proven and the investigation can be taken forward.
Right. So just to get an update for our viewers, the hearing has started at the Rouse Avenue Court. Now, Senior Advocate Vikram Chaudhary and Abhishek Manu Singhvi are representing Arvind Kejriwal, and also we are learning is that Additional Solicitor General S.V. Raju is arguing the ED's case.
And therefore, this entire arrest ahead of Lok Sabha elections is political vendetta. That is likely to be the line of argument for the defense. But like we have been pointing out, the prosecution, which is representing the Enforcement Directorate, is confident that they have enough on record to convince the court. And since they have managed to convince the court in the case of Manish Sisodia and Sanjay Singh, they feel it will be the same for them as far as the Delhi Chief Minister is concerned.
That's what the Enforcement Directorate believes. They do feel that they have a watertight case. There are several statements that have come to the fore, part of which have been part of the charge sheet in the past filed by the Enforcement Directorate. K. Kavita's remand note also does make a mention, Arunima, as far as Arvind Kejriwal's role goes.
Yes, and that was the first time that Enforcement Directorate actually in a press release mentioned the role of Arvind Kejriwal so clearly about a conspirator. Till then, there was confusion whether Kejriwal was being summoned as a witness or an accused, because Section 50 of the PMLA actually gives the IO the discretion of deciding the status of the person after the questioning, and therefore Kejriwal was repeatedly asking. But once K. Kavita's arrest happened and ED released that press statement, that was the first hint that ED is confident of a case against Arvind Kejriwal. It is moving to questioning him as an accused, and then subsequently last night we saw what happened. Delhi.
Good evening everyone. The buzzword is Bharat. Bharat, that is India. The Prime Minister has already outlined the ideological governance and cultural contours of the transition to Bharatiyata. So let's decode Bharatiya and Bharatiyata with these two fine gentlemen on the stage with me. Let me first begin with you, J. Sai Deepak. You've written a number of books. In fact, you're coming out with a third in a series. What values define a Bharatiya for you?
So, one, I think the question that is usually asked is whether this is a religious construct or a civilizational construct or a cultural construct. I think if you go by the words of Sri Sarvepalli Radhakrishnan and Swami Vivekananda, it's impossible to take religion out of Bharatiya life. And I think a lot of people have tried but have failed to remove religion from even politics for that matter. Whether that's for the good or the bad, that I think posterity will decide. But it's a statement of fact, it exists. So I believe that religion and culture go hand in hand in informing the civilizational identity of this land, which is Bharat. But the problem is, if you were to treat this as a construct which is meant to exclude certain populations from the tapestry of Bharat's identity, well, that's not the purpose of it. When you try and reclaim your identity, you're merely saying, this is who I am, and I'm happy to accommodate everybody else who does not have an antithetical relationship with this identity. So as far as I'm concerned, both Hindu Dharma along with civilizational aspects which are part of, let's say, Hindu cultural mainstream define what is Bharatiyata. During the course of the drafting of the constitution, one of the questions that was asked is that when public morality is sought to be defined and its contours are sought to be understood in the context of Bharat, what is the repository or the reservoir from which we draw those values? To which several members of the Constituent Assembly took the categorical position that dharma is the public morality of Bharat. So if you were to ask me what is the defining trait which defines Bharatiyata, then you start and end with dharma. Now, unfortunately, since English is a language which is incapable of providing a decent translation for dharma, it is typically and crudely and incorrectly translated or approximated to religion, which it is not. It's more a code of conduct, but it also has a certain set of principles which clearly trace their origins to the Hindu faith system, or the agglomeration of Hindu faith system, so to speak. So for me, in that sense, the civilizational identity of Bharat is significantly and primarily informed by Hindu dharma. But precisely because it's defined by Hindu dharma, it is capable of accommodating others who do not pose a threat to its very existence.
Mr. Anas, let's build on this opening by Jesai Deepak. The RSS and other spokespeople expect citizens from other denominations to describe themselves as Hindus. Dharma is, of course, identified very closely with Hinduness, they say, which they say is a function of Bharatiyata. Now, how does one apply it in the context of a multi-religious society such as ours?
See, my understanding of Bharatiyata, or Dharma even for that matter, has always been what I was taught as a kid in the school, अनेकता में एकता. हम वो देश थे, हम बहुत गर्व था हमें इस बात पे कि हम अलग अलग पहचान के हैं, अलग अलग धर्म के हैं, अलग अलग जाति के हैं, अलग दिखते हैं, अलग ज़बान के हैं, लेकिन हम एक थे. एक झंडा था हमारा, एक देश था हमारा, उसको हम सलाम कर रहे थे, और मेरे लिए बस वही था एक धर्म का मामला. अब जैसा दीपक ने कहा कि हिंदू धर्म डिफाइन करता है धर्म की भारतीयता क्या है, मैं इससे थोड़ा अलग मत रखता हूँ. लाजमी तौर पे मेरा ये कहना है कि जब 1950 में हमने संविधान अपनाया तो हमने इस मुल्क को एक डिसाइड किया कि हम ऐसे देखते हैं, ये ऐसा होगा, एक सेक्युलर देश होगा, ऐसा देश होगा जहाँ सब बराबर होंगे, जहाँ सबके पास समान अधिकार होंगे. आज जब आप नागरिकता पे, और मैं ये नहीं कहता हूँ कि जैसे एक बहुत ज़्यादा प्रिविलेंट आर्ग्यूमेंट है आर्टिकल 14 को लेके, मैं वो आर्ग्यूमेंट ही नहीं लेता हूँ. मैं मानता हूँ कि हाँ आर्ग्यूमेंट आर्टिकल 14 सिर्फ इंडियंस के लिए है, सिर्फ सिटीजन्स के लिए, मैं वो नहीं कहता हूँ. लेकिन जब आप पूरा उसका बेस बना देते हैं धर्म को, तो आपको ये देखना पड़ेगा कि डेमोक्रेसी जो खुद अपने आप में एक वेस्टर्न कंस्ट्रक्ट है, लेकिन हम उसको लेके चल रहे हैं और इतने उस पर गर्व कर रहे हैं, उसमें कि कौन से और ऐसा डेमोक्रेटिक या सेक्युलर देश है जहाँ पे धर्म के बेसिस पे सिटीजनशिप दी जा रही है. और सिटीजनशिप एक वो राइट है जो आप वापस नहीं छीन सकते हो. एक बार आप दे देते हो तो छीन नहीं सकते हो. तो हमें किसको दे रहे हैं, कैसे दे रहे हैं, इस पर विचार करने की बहुत ज़्यादा आवश्यकता है.
But this concept of, let's flip the word, diversity in unity, how does the CA take that forward? I know that you want to sort of disconnect the conversation from Bharatiyata, but this government claims that it is actually the one that speaks for the essence of Bharatiyata.
Right.
And it talks about a Hinduness, which it traces to a dharmic past. But if that CA is going to be, or the Dharma is going to sort of, at some level or the other, bring out an exposition like the CA, then we have a problem.
So, see, let's have this conversation on the anvils of specifics. Is there any amendment to the existing Citizenship Act which precludes the possibility of non-Hindu applicants to knock at the doors of Bharat for citizenship or asylum? The answer is a no. The CAA is a limited inclusive intervention for the purposes of addressing the unfortunate realities of our immediate neighborhood, where 3 Islamic republics have a specific problem with other identities. That's the unfortunate reality. And we are operating under the premise that Indian Islam is different from the brands of Islam being subscribed to by our neighbors. Okay? Therefore, those people who are getting the rough end of the stick thanks to their minority position in those countries are being given a certain expedited option, because the first point of attack when it comes to these countries happens to be those people who do not share the faith of the majority in those countries. Therefore, since they are the first points of attack, they are the softest targets possible, a limited intervention is being made. The myth that is being pervaded is that CAA translates to automatic vestation of citizenship. It doesn't, because they still have to satisfy the rules that have been notified. Second, all it does is that it limits a certain cutoff period from 11 years to 6 years. Two, my own criticism of the CAA, despite me supporting it in principle, is the cutoff date that has been prescribed, which ultimately translates to defeating the very humanitarian intention which is supposed to be the basis for the CAA. What is the point of limiting it to a particular date? Regardless of that, my argument still remains, I welcome it because it doesn't take away anybody else's rights. It only makes sure that those people who are being kicked out are being welcomed as soon as possible. My criticism has also been the delayed notification of the rules. So because I am not the mouthpiece for any cultural or political outfit, I am at some liberty to criticize the proponents of the CAA themselves for the delay that they have caused after taking 8 different extensions from the parliament in the notification of the rules themselves. So according to me, it's important to dehyphenate these positions from any political organization or a cultural organization, because dare I say this, a lot of us are practicing Hindus not because of a political party or because of a cultural organization, but because we have always been practicing Hindus. Their existence or absence wouldn't have made a difference to our practice in any case.
So Anas, then what's the problem? He's saying that, look, it's only fast tracking, it's not denying. You can still come in if you're Muslims, if you're persecuted in various countries, in any country, you can still come here and seek refuge.
See, to that extent, he's right. I'm also not denying that. It's not even fast tracking, let me tell you. The purpose stands defeated as of now. Because to take the advantage of CAA, the cutoff is December 2014, and you have to be in India 5 years prior, that is 2009. Now that would have fast tracked to 6 years instead of 12 years. We are in 2024, 10 years since 2014. It's already redundant, it doesn't help anyone. CAA neither helps anyone, it actually does create problem for those who are left out of NRC in Assam. Only particularly to Assam, it does create problem for them, and I will expound on that. But about the rest of the other things that dharm and saying ki, you know, I don't know if you guys remember, there was this series called Panchayat, a very famous dialogue from that कि देख रहा है विनोद अंग्रेजी में बोल बोल के कैसा बात घुमा रहे हैं. तो ये वही वाली बात है कि अंग्रेजी में बोल बोल के कहने का तात्पर्य क्या था, जैसा ही दीपक मेरे भाई ने क्या कहा कि हिंदू आएंगे तो उनका भारतीय होना ज़्यादा आसान है. आप रोज़ खबर पढ़ रहे हैं, राजस्थान से लेके लखनऊ से लेके हर जगह से हिंदूज़ हैं जिनको हमारी एजेंसीज अरेस्ट कर रही हैं ISI का साथ देने को. तो एक किसी भी रिलीजन को, किसी भी रिलीजियस डिनोमिनेशन के लोगों को आप एक ब्लैंकेट वो थोड़ी दे सकते हो कि तुम आए हो, तुम हिंदू हो तो तुम अच्छे भारतीय हो गए. ये इसकी कोई सेंस ही नहीं बनता है इस बात का. ठीक है, ओथ ऑफ एलिजेंस तो सभी को लेनी है, लेकिन इस बात का कोई सेंस नहीं बनता. यानी इससे बेतुकी बात तो मैंने
रीजनेबल क्लासिफिकेशंस
reasonable classification
by many countries.
Let's talk about Hindu. What about the Tamil Hindus from Sri Lanka? What about the Buddhists from China and other places? For that, I mean, we have a. So आपने उनको क्यों छोड़ दिया? अगर आपको लेना ही था, and I understand कि आपकी अलग पॉलिसीज वही है तमिल्स के लिए, आपने उनको वो दिया, लेकिन सिटीजनशिप तो नहीं दिया आपने उनको रेफ्यूजी उसका दिया, सिटीजनशिप नहीं दी. तो आपने तो हिंदू के साथ भी पूरा कोई अच्छा तो नहीं किया है, आपने उनको भी छोड़ दिया है. दूसरी चीज़ मैंने कहा, मेरे CA से कोई क्वारल नहीं है. इट डजेंट अफेक्ट मी एट ऑल. मेरी सिटीजनशिप सेफ एंड सिक्योर है. लेकिन असम में 19.4 लाख लोगों की सिटीजनशिप चली गई है. वो भी नेचुरलाइजेशन के लिए अप्लाई कर सकते हैं उसमें से. लेकिन अगर अब CA के तहत अगर उनको करना पड़े, मैं ये नहीं कह रहा उनको सिर्फ इसी के तहत करना है, लेकिन अगर करना पड़े तो 2 लाख जिसे असम में ज्योतिवादी कहते हैं, जो हमेशा अपने को असमीज कहते रहे हैं, अपने को इंडिजीनियस कहते हैं, वो भी तो बाहर हैं. क्या वो खुद को पहले बांग्लादेशी प्रूव करेंगे हिंदुस्तानी कहलाने के लिए? इससे बड़ी एब्सर्ड कोई चीज हो सकती है कि हिंदुस्तानी को हिंदुस्तान के सिटीजनशिप के लिए, नेचुरलाइजेशन के लिए खुद को पहले बांग्लादेशी प्रूव करना पड़ेगा.
Okay.
I'll try and make sense of the garbled argument presented here and see if I can unpack a few layers from
garbled argument.
Yes.
Okay.
So first, see, here's the point.
Yeah.
Ever since the end of the LTTE, situation has normalized to such an extent that Tamil Sri Lankans are not being forced to flee that country. That is a fact. The fact of the matter is, if Bharat had an equation or at least the ability to pressurize Pakistan, Bangladesh and Afghanistan to the extent that they could treat their Hindu minorities with some degree of dignity, then the CAA would actually be irrelevant and unnecessary. Because ultimately, it's a question of what is your relationship with those countries, what is the treatment of those populations by their native governments. Today, nobody can accuse the Sri Lankan government of meting out the same treatment to Tamil Sri Lankans the way Hindus of Pakistan are being given treatment by Pakistan, Bangladesh or Afghanistan, so to speak, in those countries. So if you can ensure that they can stay in their own countries without creating any further trouble for themselves or for us, we would want them to stay there. So therefore, the entire argument is this, that Bharat must effectively apply an open Dharamshala policy in the name of the CAA, and the CAA is unconstitutional precisely because it doesn't open its doors to every persecuted community under the sun. Frankly speaking, this makes a mockery of the concept of sovereignty and our own borders and our own sovereign interest and security interest. I have no reason to trust a Muslim from Pakistan, Afghanistan or Bangladesh, period. Because ultimately a choice was made, and therefore I will certainly view them with a certain degree of suspicion, a heightened degree of suspicion compared to people coming from the Hindu community in those states. That's a fact.
But the Hindus in Pakistan stayed back in Pakistan.
Here's the funny part.
The Hindus in Pakistan stayed back in Pakistan.
Their entire argument is, the Hindus of Pakistan stayed back. Why? Here's the point. When Pakistan was created, the question was, how do we divide land for this area called Pakistan? So the existing population of Muslims in this country and undivided Bharat was taken into account based on the 1946 elections, and then the area was divided. Despite 90% of the population of Muslim community before 1946 voting for the state of Pakistan, the bulk of them stayed back.
That's wrong.
That's a fact. It's a fact. It's a documented fact. You won't get to actually deny these facts.
It is out of
So today
context.
we are being told,
it loses in
we are
nuance.
being told everybody who stayed back for purposes of patriotism. Sorry, 1946 elections proved whose allegiance were where. Secondly, here's the important thing. The Hindus of
So you're talking about the 1946
Yes, I'm saying,
elections
why did
and the
Hindus stay
results
back there?
in the Muslim provinces where a large number of Muslims voted for
Ultimately, it's like this.
Muslim
Assume for a
league.
moment, you have a 6-bedroom house.
Yes.
Out of that, one portion of the family says, we are X number of people, we need 50% of the house. Ultimately, only 2 people shift to that portion of the house which is being given for 50% of the family. The rest of them stay back. Now, because we are constantly told that Dr. Ambedkar is the framer of the Constitution, and we are expected to constantly kowtow to him, why would Dr. Ambedkar speak of a complete exchange of populations after 1946 and after the elections if he wasn't aware of the ground reality when he was actually part of the drafting committee of the Constitution? So why is it that Ambedkar is selectively quoted and cited in other contexts? Why don't we quote him in this context? What did he say in his book, Pakistan or the Partition of Bharat? What did he say with respect to the reasons for population change? Why did he actually bat so vociferously for population exchange more than even Madan Mohan Malviya for that matter? Madan Mohan Malviya is the founder of the Banaras Hindu University in 1916. These are all people who were participants in the Sangathan movement. The one who openly wrote a book asking for exchange of the Muslim population of Bharat with the Hindu population of undivided Pakistan, so to speak, was Dr. Ambedkar. What is the response to that? So if you have a problem with this argument, go ahead, call Dr. Ambedkar an Islamophobe. We'll see what happens after that.
1946 में इन्होंने कहा कि 2-4 लोगों ने वोट दिया, 2 गए. भाई वोट का अधिकार कितनों को मिला था? आपने उस टाइम पे भी अंग्रेजों ने ही दिया था, जो दया भाव था या हम जीते थे, जो कह लो.
But you can't deny the facts.
No, I'm not denying. See.
80%.
80% कहाँ? I'm denying this. It's not 80%.
86.
आपने 100 लोगों में 100 लोग की जनसंख्या में से 10 को दिया वोट का अधिकार. वो 10 थे जमींदार जिनको मिला, जिनको कहते हैं कि अलीगढ़ के बच्चों की लौंडों की बदतमीजी है पाकिस्तान. हमेशा ये कहा जाता है कि अलीगढ़ के लौंडों की बदमाशी है ये. तो ये वही था. पाकिस्तान तो अलीगढ़ के लौंडों की बदमाशी था. उन्हीं को तो आपने अधिकार दिया था वोट का. हम जैसे, चलो हमारे भी रहा होगा, हमारे ठीक ठाक घर से आता हूँ मैं, लेकिन बाकी जो गरीब थे वो थे, उनको अधिकार नहीं मिला था, औरतों का अधिकार नहीं मिला था. एक तबके को मिला था. वो तबका पाकिस्तान चला गया, उसको वहाँ पे बहुत ज़मीन मिली है, वो बहुत अमीरी से, क्योंकि पाकिस्तान ने तो अपना ज़मींदारी एबॉलिशन भी नहीं किया. तो इन लोगों के पास ज़मीन वमीन है, वो वहाँ खुश हैं. हम आज तक उनका झेल रहे हैं. हमसे तो कोई मतलब ही नहीं था, हमारे पास तो वोट था ही नहीं.
The spirit of the agreement gave both the countries a say in the welfare of the religious minorities across each other's borders.
Because of our history.
Unfortunately, in Pakistan, they broke that contract, that agreement. Now we fear for the future of the religious minorities, the Hindus, the Sikhs, the Christians, the Buddhists, the Jains, and the others.
So they say, where are the Jews? There was only one Jew according to the census of Pakistan. So they are saying that
Jews is not a question. That's not the point.
So here's the point. If you read Articles 5 to 11 of the Constitution, that is entirely Pakistan-centric when you're defining citizenship as part of your own constitution, because you realize that there's a continuing cord that connects you with the people there. It also speaks of how many people can go there. When you come back, what happens to your citizenship, so on and so forth. So in the backdrop of your specific history of the subcontinent, considering the basis for the partition, for us to say we owe no obligations whatsoever, despite the Nehru-Liaquat Pact, according to me, is to make an argument in vacuum when there are clear documented facts to the contrary.
Look, I get the sense.
Can
I ask a provocative question?
Lekin I'm very thankful to my friend here. He knows that I'm fasting and I can't speak much, so he's doing all the speaking.
मेरा Tuesday fast चल रहा है.
नहीं आप पानी तो
हनुमान जी का fast चल रहा है.
But I'm being thankful to you. Why are you getting agitated? I'm just being thankful to you. Don't get so angry. You need not be so angry. हम लोग बहुत गुस्से वाले हो गए. क्या हो गया है? शांत हो यार. अच्छा है सब.
These are responses to my arguments. Please continue.
हाँ, अब मैं आता हूँ उस बात पे. मैंने कहा मेरा सीए से कोई क्वारल नहीं. मैंने शुरू में ही कहा था. मैं फिर से वापस आऊँ. मेरा क्वारल क्यों होगा? थोड़ा सा है. वो है अनकॉन्स्टिट्यूशनैलिटी पे. मैं संविधान को मानता हूँ. मैं संविधान के अगर कोई चीज अनुरूप नहीं है, कोई कानून, तो वो गलत है.
Okay, so one very quick question that many people bring up, Article 14, ultra-virus.
No, I'm on Article 15. I'm not on Article
15. Okay. A quick response. It's just ultra-virus of the Constitution.
Can I explain that? Then you can rebut that. Okay, my argument. Let me place my argument.
Okay.
Section 31C of Citizenship Act, which came by the 2003 amendment, for the first time said that a child born in India will be an Indian citizen if either of the parent are Indian citizen and the other is not an illegal immigrant. I'll wrap it up. Okay? Is not an illegal immigrant. Now place this like this. I am a Muslim, born after 2003. I'm an Indian citizen. My mother is not.
Sure.
My mother is an illegal immigrant. Similarly placed, there is a Hindu kid. On the same footing. He can take advantage of the CA, I cannot. Article 15 says there cannot be a discrimination on the basis of race, religion, caste, gender, so on and so forth.
1 minute, 20 seconds.
The problem with this argument is that a Pakistani Hindu refugee who has come through a legitimate refugee channel is being equated with a Bangladeshi Muslim immigrant who has come through the illegal channel as part of this particular definition.
Talking about born in India.
When Pakistani Hindu
I'm
refugees...
talking about Indians. I'm not even talking about Pakistanis.
A Pakistani Hindu refugee and an Indian parent, so to speak, when they combine, it's a marriage between an Indian citizen and a refugee within Bharat, which is recognized by an Indian law. But when an illegal migrant wants to marry a citizen, that is not the same as a refugee marrying a citizen. That's point number one. Two, since we are constantly being told equal treatment, we should be concerned about the people here, we should always think about only the people here. What is my friend's position on the Uniform Civil Code?
See, this obsession, I'll come.
No, it's not an obsession. It's a legitimate question.
See, jumping, ज्ञानवापी दे दो, ये कर दो.
It's
a matter of
तुमने संविधान के पे, I raised a question on point of law, you did not respond.
Mr. Anas, let's not change the goalpost. He's asked you a valid question. We've got 20 seconds. I'm asking you. The Constitution itself says we should give ourselves a uniform civil code. The Supreme Court itself...
It is part of DPSP.
Yes,
it is not part of fundamental right. First, let me realize my fundamental rights. That is the priority.
It is an objective of the Constitution of India.
No, fundamental rights are the priority. First, give me that.
It is a directive principle. You aspire towards that.
The state aspires for that.
It is an ideal that we must aspire to, as the Constitution also upholds many other ideals to aspire to. No, not time.
You won't give me time to respond and you...
Please, go ahead. 1 minute.
See, no, you haven't even raised a question. What will I respond?
No, I've asked you. I said, how are you saying that this is a...
See, UCC is part of DPSP. मैं अभी fundamental rights की लड़ाई लड़ रहा हूँ. अभी मेरे पास खाने को नहीं है. इस देश में इतने लोग हैं जिनके पास मूलभूत चीजें नहीं हैं.
So it's okay if exceptions are made for certain communities.
Exactly.
those
preserve
exceptions
our
can
respective
stay.
religious freedoms and give us the ability to oppose anybody else who is being actually affected in Pakistan. That's the simple
Article 12,
argument.
which is part of fundamental right, protects my personal right.
Okay, gentlemen, you know, I didn't anticipate such passion, but we find that, no, but look, at least debate is alive in this country. So tell all those people out there that we can debate without fear or favor even the trickiest issues in India today. I'll leave it at this. Thank you very much.
Good evening. You're watching The Right Stand with me, Poonam Burde. It's been about 24 hours since Arvind Kejriwal was arrested. What has been witnessed since then is a shrill political face-off and a fight that poured onto the streets, not just at the national capital, but many other cities across the country. Now, many would say that life has come full circle for Arvind Kejriwal. From leading the India Against Corruption movement to now facing a serious corruption allegation himself. Look at those two images on your screens. One is from 2012, where Arvind Kejriwal was arrested when he was spearheading the anti-graft movement. 12 years later, he's been arrested again. This time, he's accused of formulating a policy that benefited his party's coffers. The Enforcement Directorate today told court that they have concrete evidence to show that the excise policy was changed only to fund the Goa elections by the Aam Aadmi Party. In its remand application, the agency said that Arvind Kejriwal is guilty under Section 3 of the Money Laundering Act. Guilty or not is for the justice system to decide. But the timing of this arrest does not augur well for the Aam Aadmi Party and for its allies who today stand by them. Now, during the hearing over Kejriwal's remand, the order of which is still reserved, a heated debate ensued between the Enforcement Directorate lawyer and Arvind Kejriwal's legal team. While citing a 100 crore plot, the ED claimed that Kejriwal is a key conspirator of the alleged scam. He was the kingpin, is what they said. The Aam Aadmi Party rejected that claim. They said it's a pre-poll crackdown by the agency at the behest of the ruling dispensation. We need to show the necessity to arrest, is what they said. Additional Solicitor General S.V. Raju, who appeared for the Enforcement Directorate, tagged Arvind Kejriwal as the kingpin of the scam. Abhishek Manu Singhvi, who was representing Arvind Kejriwal, argued that there is a need to show the necessity to arrest, which the ED had not. ED alleged that Kejriwal had disobeyed multiple summons and that he did not give correct facts to the agency. To which Arvind Kejriwal's defense said that there was nothing to show that he cannot give this required information without his arrest. ASG Raju argued that those involved in functioning were deemed to be guilty. To which Kejriwal's counsel said that the reason to believe and the material